We begin this morning with the judge who oversaw the Parkland shooting trial for that school shooting that happened recently. The judge recently, incidentally, decided that they wanted to resign from the bench in part of their term. And this has ultimately culminated in the judge receiving a reprimand in relation to this. So the judge's behavior was so concerning to the bar and the judicial establishment that the judge received an official reprimand. So let's learn a little bit more about what happened in this trial. Let's discuss some of the implications for this case. Let's get started with this. The Florida judge who oversaw the penalty trial of the Parkland shooter, Nikolas Cruz, should be publicly reprimanded for showing bias towards the prosecution, failing to curtail vitriolic statements directed at Cruz's attorneys by the victims' families, and sometimes allowing her emotions to overcome her judgment, according to a state commission. Okay, so Nikolas Cruz was on trial for 17 counts of murder and 17 counts of attempted murder in relation to this school shooting. Somewhat notably, the jury came back non-unanimously on the issue of the penalty, which meant as operation of law, the judge had no choice but to sentence the person to a non-death penalty result, which in this case, of course, would have been the multiple life sentences served consecutively. And this was so outrageous to some people in Florida that Florida recently passed a bill to allow non-unanimous juries when it comes to the question of the death penalty, which incidentally, there's a U.S. Supreme Court case directly on point that says that it has to be unanimous. So I don't know if Florida's trying to change the law or what, but they passed a law that's directly in defiance of this. So someone somewhere is going to get sentenced to life without the possibility, or someone's going to get sentenced to the death penalty, and the Supreme Court will eventually overturn it. But that's how outrageous people were about the whole thing because of this situation. And now it has been suggested that perhaps the judge may have, from her behavior, influenced the trial in a way that showed favoritism to the defense and antagonism towards the prosecution. The Judicial Qualifications Commission found that the Circuit Judge Elizabeth Scherer violated several rules that govern judicial conduct during the trial towards Cruz's public defenders. The 6-month trial ended with the Cruz receiving a life sentence for the murder of 14 students and 3 staff members, thus leading to 17 people. After the jury could not unanimously agree on the death sentence, I believe they were 11-1, and I think on one of the counts they were 10-2. So there were multiple different death counts. I think some of them were 10-2, some of them were 11-1, but they couldn't come unanimously back on any of them. And so therefore, the operation of law is the multiple concurrent life sentences. The 15-member commission reviewing the judge's behavior found that the judge had unduly chastised the public defender and her team, wrongly accusing Cruz's attorney of threatening her child, the judge's child, and improperly embraced members of the prosecution in the court after the trial's conclusion. This would be the hug that we saw on camera, which, was not a great look, because it clearly shows, why didn't you hug the defense's attorney? Because this was probably pretty hard for them too, one would imagine. Probably went through a whole panoply of emotions. But you don't care about them because they represent the bad people, so their feelings don't count, I guess. Even though they did their job as they're sworn to do, as public defenders in the state of Florida. You didn't embrace them, you embraced the prosecution team after chastising them publicly and accusing them of threatening your own child and stuff like that, which, showed a little bit of hostility. The commission, which is composed of judges, lawyers, and citizens, acknowledged the worldwide publicity surrounding the case creates stress and tension for all participants. Yeah, but you're a judge and you have to try to adjudicate things in a way that's fair. And you're not supposed to have favoritism. You're not supposed to have any sort of bias. You're not supposed to have prejudice nor favor towards any participant. And here you showed open hostility to the defense and open favoritism to the prosecution. So it kind of failed on that judge job, which might be why you recently resigned, because you realized you weren't cut out for it. So, all right. Regardless, of course, of any emotional issues, the commission said judges are expected to ensure due process, order, decorum, and act with dignity and respect to promote integrity and impartiality of judiciary. Of course, not only impartiality in fact, but also impartiality in perception. Both are important in the judicial canon of ethics. The duty to be fair and be perceived as fair. right? The result must be legitimate and be perceived as legitimate. These are good goals because if people don't have confidence in the result of the system, they'll be less likely to accept the results of the system. So it's not only important that they come to correct results, but they be perceived as correct, or at least fair, or at least in operation of the law. And when judges don't do this, it leads to problems because, hey, wait a second, it undermines our confidence in the underlying verdict. Maybe that verdict was not correct. In limited instances during a unique and lengthy case, the judge allowed her emotions to overcome her judgment, said the commission, in response to the Florida Supreme Court, which will make the ultimate decision, of course, as the ultimate legal authority in the state of Florida. This is a similar process as well towards the lawyers as well. And every once in a while, you see the Supreme Court of the state defy or go against the recommendation. And incidentally, sometimes they go against it both ways because they are the ultimate authority. So sometimes you'll see the commission or the review board or whatever it is recommend a lower punishment, and sometimes they'll actually institute a higher punishment or the reverse because it's the Supreme Court and they can kind of do what they want. So you normally expect the Supreme Court to adopt the result. You wouldn't typically expect any other outcome in this situation because the nature of the violations are probably not egregious enough to warrant more than a public censure. But at least to a lawyer, a public censure is a pretty big deal. Being called out on the record in public and to have that attached to your law license and you have to report that to other bar associations and stuff. Public reprimand is a pretty big deal for most lawyers. So it would definitely get my attention. Let me just say that. The judge announced last month she would be retiring from the bench effective June the 30th. The commission said the resignation was not part of any deal struck with the judge. The commission report said the judge acknowledged during her testimony that her conduct fell short of what was expected, and her treatment of members of defense teams was at times not patient, dignified, or courteous. Well, she recognizes the truth, and she realizes that perhaps she wasn't really cut out for this. So she resigned halfway through her first term as a judge. So, that's fair enough. Not every job is for every person. She realized that she wasn't for her. So, okay, go back to doing something else maybe. The judge was a former prosecutor appointed to the bench in 2012, and the Cruz case was her first capital murder trial. Broward County system randomly assigned her the case shortly after the shooting, which is also pretty typical. That's normally how cases get assigned in most jurisdictions. It's a random assignment, right? That way you don't get your choice of judge, because we do recognize that judges are human beings and are subject to their own biases, and no judge is perfect. So we try to find the best judges that we can, obviously, the ones who are most able to put aside their personality and most able to just apply the law. But there is a human element to it, and we recognize that. And so one of the ways we try to mitigate for that is through the roll of the dice. So, which judge are you going to get that day? Will it be one that will help you or one that will hurt you? Well, everyone has an equal chance. I mean, for that matter, the same is true of a jury at large, right? We've tried to find jurors who are relatively unbiased when it comes to the case, but we can't put aside their underlying personality. So in some ways, we do the same thing when it comes to juries. It's a little bit of a roll of the dice. You get 12 members of the public and you hope for the best because we don't have any better alternatives because of the human experience. The judge's attorney, because of course, being a smart attorney herself, when she is being sanctioned, she hires an attorney to represent her because of course she does, because she's not an idiot. So the judge's attorney did not immediately return the call or email that sought comment. So she probably saw the writing on the wall. She decided to mitigate her own damages, and well, this is where we are. The public defender also declined to comment in relation to this incident. The handling of the case drew frequent praise from parents and spouses of the victims, who said she treated them with professionalism and kindness, but clashes with the defense's attorneys drew skepticism. So yeah, she was very kind to the victims. She's very kind to the prosecution team, but not so kind to the defense. So, that's a bit of a problem because innocent till proven guilty, and even where a person pleads guilty, their sentence has to be decided in a fair and objective way. Before the trial, she criticized two reporters from Sun Sentinel newspaper for publishing a sealed educational record they obtained legally. So the newspaper over here obtained a copy of a record which had been sealed, but the newspaper itself obtained the copy through legal means. And she's like, but I sealed it. Well, you might have sealed it for the purposes of your trial. You might have sealed it for the purposes of your hearings, but that doesn't preclude them from getting access to the information through other means. And you're like, why did you look into the information I had sealed? Because we were curious. Yeah. She threatened to tell the paper what it could and couldn't print, but never did. Yeah, that's always a good moment when judges are trying to tell newspapers what they can and can't print. Something about a Pentagon's paper case comes to mind very directly when we have issues like that. Legal experts said such a move would have been unconstitutional. A little bit, yes. A judge telling you in advance what you can and cannot print, it's almost like restraint of a prior nature. I wonder if there's any Supreme Court cases about that. Yeah. The judge also had frequent arguments with the defense. They boiled over for the first time when the defense and the team suddenly rested their case after only calling a small fraction of their witnesses. So yeah, this was an interesting little moment in the courtroom. The defense, for whatever reason, had initially scheduled a much longer period of calling witnesses, and they only called about half of their witnesses, or maybe it was a little bit less than that. But they only called half of the witnesses they expected to have. And then they're like, so the judge is like, well, who's your next witness? This was a little hearing that, was publicized. Well, who's your next witness? Well, we don't want to say. And the judge is like, well, no, I need to know. Who is your next witness? And so after a little bit of back and forth on this issue, the defense says, we rest at this time. And the judge got really pissed because, like, you didn't tell us. We brought the jury here this morning. You didn't bring it to our attention. Now I have to send the jury home. They've been sitting in the back for 2 hours waiting to hear his testimony, and now I have to send them home with nothing. And they asked the prosecution, are you ready to go? It's like, no, we're not ready to go because we thought there'd be another 3 weeks of defense witnesses. So none of our witnesses are here right now. So she got really, really pissed at the defense for this move, for whatever reason they did. So that was a little moment. The judge called the defense's action the most uncalled for, unprofessional way to try a case, though the defense, of course, has no legal obligation to call its witnesses or announce its plans in advance. It doesn't. It has no obligation to do that. It's part of trial strategy. Now, when the judge asks you a direct question, you have to answer it, but they don't have to otherwise inform the judge. So when they were finally pushed to give a direct answer, they answered the question honestly, which is their only obligation. But the judge was really mad. So why didn't you tell us in advance? My schedule, my precious, precious schedule. Well, the defense had a strategy they didn't bother to tell you about. Not like the prosecution's telling their strategy, by the way, in terms of what witnesses they'll call, or in what order, or what questions they're asked, or what their theory of the case is, or anything else, right? The prosecution has an obligation to turn over evidence. They have an obligation to turn over material in sort of what they'll use to convict you or what can be used to keep you out of jail, right? They have the obligation to give you Brady material. But the prosecution's strategy, not so much. The prosecution's theory of the case, not so much. Witnesses they're going to actually call, and in what order, not so much. So, yeah, that's pretty normal. The defense said, you're insulting me on the record in front of my client before the judge told her to stop. The judge then laid into the defense lawyer. You've been insulting me the entire trial, the judge barked at the defense lawyer, arguing with me, storming out, coming late intentionally if you don't like my rulings. So quite frankly, this has been long overdue, so please be seated. Not one of the judge's finer moments. By itself, probably not enough. By itself. But in combination with other things that shows disdain for the defense, it's probably not any one thing. It's probably not this interaction. It's probably not even hugging the lawyers for the prosecution after the fact. It's not any one thing. It's the combination of things that shows a pattern of conduct, that shows a bias. That's the problem. So, yeah. The two then clashed again during Cruz's sentencing hearing over verbal attacks some family members made against the defense team during their courtroom statements. The judge refused to curtail the statements and ejected one of the assistants. after she wrongly interpreted one of his comments as a threat against her daughter. Yeah, I would as a judge remind the gallery that the defense lawyers are not the defendant and are not the bad people. So attacking the defense lawyers is not called for. The defendant's the one who did the bad job, the bad thing. The defense lawyers are representing their client. So I understand the defense lawyers being a little peeved that they're getting called out by family members during sentencing hearing. We're supposed to be talking about the defendant. Like, why is he good or why is he bad? What factors in aggravation or what factors in mitigation? Or how has he harmed you? Or what problems has he caused you? The defense team didn't do nothing to you. And the judge didn't do anything to like curtail it, which I would have done. Be like, your comments towards the attorneys are not proper because they're not the ones being sentenced. And also they didn't do anything wrong. So the judge not acting and not interfering with this again by itself, is it enough? Probably not. In combination, it suggests more of a pattern. After sentencing Cruz, who is 24, to life without parole as required, the judge left the bench and then hugged the members of the prosecution and the victim's family. She told the commission she also offered to hug the defense team. Did she, though? Did she offer to hug the defense team? Because I don't remember anything like that happening. But maybe it was just me. I'm not sure what the defense has to say about that, but I don't really remember that moment, but maybe my memory's a little bit faulty. Okay. The action then led the Supreme Court of the state in April to remove her from overseeing post-conviction motions of another defendant who was sentenced for murder. So the Supreme Court of the state is so concerned about this. You're like, yeah, you can't be a judge in this context right now while I figure things out. Not a great sign. One of the prosecutions of the case had also been on the Cruz team. And during the hearing, in a case a few days after the Cruz sentencing, the judge apparently asked the prosecutor how they were holding up. So the prosecution is now involved in another death penalty case, sentencing. And we're like, how are you holding up from the last hearing? Well, again, in isolation, probably not a problem. In combination, suggests maybe some bias. The court said that the actions at least gave the appearance that they couldn't be fair, which, yeah, that is a concern. It's right in the Judicial Code of Ethics. You have to be fair and also perceive to be fair. When you do things like this that suggest that you are not fair, the failure of perception is in of itself a problem. We need people to have confidence in the judicial system. We need people have to have confidence in the result and the process, which I think they should have confidence in. I think it's something that is worthy of confidence. And when you do shit like this, it naturally undermines people's confidence. So stop doing that, please. That'd be great. Thus, that brings us to the end of the case of the judge who oversaw the Nikolas Cruz trial, who, among other things, hugged the prosecution team in the aftermath of the sentencing and also reprimanded the defense lawyers. And also didn't prevent the gallery from chastising the defense lawyers, who were, of course, doing not their job ethically, constitutionally, and within the bounds of the rules that they were sworn to do. And she didn't make a point of being like, this is an asset of the system. This is the point. You know, when we have a good defense team, it therefore increases our confidence in the result. The defense team pressing the stain gives us increased confidence in the result. The very fact the defense is there to challenge the prosecution and make the prosecution prove their case helps us have confidence in the outcome. So rather than condemning the defense, we should praise the defense. And also, it's constitutionally required. And also due process. And also innocent until proven guilty and the rest of it. But she didn't do any of those things. And so she resigned from the bench and now has been publicly reprimanded, which is one hell of a slap in the face. At least that's the way I perceive it. So a lot of mistakes were made along the way. And also the Supreme Court of the state will ultimately have authority on this for whatever sanction they deal out. But it's not going well through the commission. And that, for the moment, brings us to the end of the discussion of this story.